In this lecture video, we will be discussing civil commitment, and in particular, involuntary civil commitment. So what is civil commitment? Well, it's essentially psychiatric hospitalization to treat a mental disorder. Commitment can be criminal or civil, and voluntary or involuntary. It can be considered a criminal commitment when there's some sort of criminal justice involvement for the person with a psychiatric problem. The hospitalization can occur pre-trial if a person is exhibiting mental disability while they are still charged with a crime, or it could be post-trial if they exhibit the mental problems after they've been convicted. Civil commitment is involved when the person is not involved in the criminal justice system but is in need of psychiatric help. The processes for civil or criminal commitments are similar, however the ultimate treatment location can differ. A commitment can also be voluntary or involuntary. Voluntary commitment is one where the person submits himself or herself to receive treatment, whereas involuntary treatment involves a situation where a person may not have the insight that he or she needs such treatment, and therefore the psychiatric care is imposed on the person either in an outpatient setting or in a hospital. So why do states allow involuntary commitment? Perhaps the most clear and oldest reason for civil commitment is to help people in need. Under the parens patria power, a state can help those who can't or won't help themselves. This was the original justification for involuntary civil commitment. However, over time, states became more concerned about the impact mental illness can have on the person themselves and others. Therefore, the police power came into play as a justification for civil commitment. So, involuntary civil commitment has been used to protect others from persons who have mental illness, as well as to protect the mentally ill from themselves. So to answer the question, what gives the state authority to involuntarily commit someone, it's actually both the parens patria power and the police power. Across the country, there are typically two criteria required to involuntarily hospitalize or civilly commit someone. The person must first have a mental illness, which is sometimes called a grave mental disability in state statutes. And secondly, the person must be a danger to themselves or to others. This second requirement comes from a 1976 U.S. Supreme Court case called O'Connor v. Donaldson, where the court found that without dangerousness, it was not constitutional to hold someone against their will for psychiatric purposes. So you need both criteria for involuntary commitment to be valid. One without the other is just not good enough. If a person is just mentally ill and not dangerous, there are other less invasive behavioral health interventions that can occur. If a person is just dangerous without having a mental illness, then they shouldn't enter the mental health system, but rather be dealt with through the criminal justice system. So by what standard of evidence do these two criteria need to be proven by? In another U.S. Supreme Court case called Addington v. Texas, the court found that the criteria must be proved by clear and convincing evidence. In other words, the middle standard of evidence, not the criminal standard of beyond a reasonable doubt, and not the usual civil standard preponderance of the evidence. This is because even though it's a civil process, the person's liberty is in jeopardy. In other words, they could lose their freedom, so greater scrutiny is required. Now, many people think that once someone is committed to a psychiatric hospital that it immediately means that they are incompetent, but this just is not true. Civil commitment just means that they have a mental illness and that they are a danger to themselves or to others. They can still be competent to do many things, so commitment does not equal incompetence. In Florida, civil commitment is governed by the Baker Act. The Baker Act was named for a Miami area legislator, Maxine Baker. She was instrumental in the early 1970s in making major revisions to the Florida Mental Health Act so that individual rights were a greater focus. So the statute ultimately became known as the Baker Act. The 1971 legislative changes were a reflection of the civil rights movement across the country, which increased due process and patient civil rights. The Baker Act was again revised in 1996 in response to a newspaper article series that focused on the inappropriate use of the Baker Act to hospitalize older adults who lived in nursing homes. The 1996 changes included increasing protections for vulnerable populations, stronger informed consent and guardian advocate provisions, and expanded notice requirements. That is, family members and others received more prompt notice of Baker Act processes. Finally, in 2004, there were some additional changes to the Mental Health Act. Those included adding mental health counselors to the list of professionals who could initiate Baker Act proceedings, and new outpatient commitment provisions. Outpatient commitment allows receiving facilities and other hospitals to discharge committed patients to mandatory community treatment under certain conditions. This allows for a less intensive treatment for some individuals who didn't need to be in an inpatient setting, but still needed mandatory and voluntary treatment. The Baker Act outlines procedures for several processes, including voluntary admission, where someone seeks out treatment for themselves, involuntary examination, where a person can be taken to a receiving facility and go through an assessment to see whether they indeed meet Baker Act commitment criteria, and such examinations can take up to 72 hours to complete. Involuntary placement, where a person can be hospitalized for up to 6 months if the treatment receiving facility can prove in court that such a placement is necessary. And finally, outpatient commitment, where a person can be involuntarily committed to receive certain treatment while still living in the community. At all points in the procedures under the Baker Act, there are safeguards to ensure that the person's individual rights are as protected as possible. The commitment criteria in Florida are actually a good example of what many states use as criteria. The criteria are stipulated in Section 394.463 of the Baker Act, and it reads, "A person may be taken to a receiving facility for involuntary examination if there is reason to believe that he or she is mentally ill." So the first criteria is met, requiring mental illness. And because of his or her mental illness, 1, the person has refused voluntary examination after conscientious explanation and disclosure of the purpose of the examination, or 2, the person is unable to determine for himself or herself whether an examination is necessary. This part just makes sure that the person can't or won't voluntarily commit themselves. Secondly, 1, without care or treatment, the person is likely to suffer from neglect or refuse to care for him or herself. Such neglect or refusal poses a real and present threat of substantial harm to his or her well-being, and it is not apparent that such harm may be avoided through the help of willing family members or friends or provision of other services. Or 2, there is substantial likelihood that without care or treatment, the person will cause serious bodily harm to himself or herself, or to others in the near future, as evidenced by recent behavior. So this is the second element, the requirement of dangerousness. That is either severe neglect or specific harm. So again, we need mental illness and dangerousness to self or others, and the Florida statute is very specific about it. So given that criteria, who can initiate a civil commitment petition or a civil commitment process in Florida? There are 3 types of people who can do that. First, a law enforcement officer can initiate it. Law enforcement officers include sheriffs, the police, university police, and other public officials charged with protecting citizens. Law enforcement officers are currently responsible for about 49% of the Baker Act initiations in Florida. The second source of Baker Act initiations is the courts through the ex parte process. What this is about is that anyone, you, me, the barista in your Starbucks, anyone, can petition the court to initiate a civil commitment process for another person. This is most useful for family members who are concerned about their loved ones and who may wish to have them involuntarily committed. Court initiations account for about 2% of the Baker Act initiations in Florida currently. The final type of people who can initiate a Baker Act process in Florida are mental health professionals. These include psychiatrists, psychologists, social workers, and others who are trained mental health professionals. Mental health professionals currently account for about 49% of the Baker Act initiations in Florida, very similar to law enforcement. Once a Baker Act process is initiated, the clock starts running at the receiving facility, which is essentially a residential psychiatric facility. It has 72 hours to examine, evaluate, and assess the person who's been Baker Acted. At or before 72 hours has elapsed, one of 3 things must happen. First, the patient could be released if they feel that the person does not meet the Baker Act criteria. Secondly, the patient could shift to a voluntary admission, where involuntary commitment process would not be necessary anymore. Finally, the receiving facility could petition the court for an involuntary placement. The court must consider and rule on the petition within 5 days. That is, the court must have a hearing within 5 days about the involuntary placement petition. If the court, after the hearing, finds by clear and convincing evidence that the patient meets the Baker Act criteria, the patient can be placed in a psychiatric facility for up to 6 months. So combining the 72 hours or 3 days in the receiving facility with the 5 days that the court has before they must conduct a hearing, a person could theoretically be held for 8 days before a decision is made about whether they should be released or involuntarily committed by the court. Here's a copy of the Baker Act initiation form that mental health professionals must complete to initiate an involuntary examination. This form is also available in the reading materials for this module. As you can see, it follows the Baker Act criteria almost exactly. It first requires the mental health professional to provide a diagnosis and then identify what profession the initiator is from. It then addresses the specific criteria with a description of the mental illness that the person allegedly has, and then has check boxes confirming whether the person was willing to seek treatment voluntarily, and then whether the person suffered from severe neglect or was a harm to himself or others. That is, whether the person was a danger to themselves or others. At the bottom of the first page, space for supporting evidence is provided. On the second page, space for other information is provided, as well as information regarding non-compliance with an outpatient placement order, if applicable. The remainder of the second page is to provide information for police officers who are transporting the individual to the receiving facility, including descriptions of the person, their age, etc., and for signatures. So that's it. These 2 pages are all that need to be completed to have a person involuntarily hospitalized for an examination. The person will then be held for up to 72 hours while being examined. Another Florida statute that behavioral health care professionals need to be aware of is the Marchman Act. This act allows for voluntary or involuntary assessment and treatment for substance abuse problems. There are 5 types of processes that can be initiated under the act. First, law enforcement can initiate a protective custody process. Second, physicians can initiate an emergency admission for detox and evaluation. Third, parents can initiate an assessment for minors or children under their care. And finally, a petition may be made to the court to initiate an involuntary assessment or involuntary treatment. The criteria that are used to determine whether someone can be involuntarily assessed or treated is that the person must be substance abuse impaired and 1. Lost the power of self-control with respect to substance abuse, and either A. has inflicted or attempted to inflict physical harm to self or others, or B. in need of substance abuse treatment and unable to appreciate the need for services. The length of potential involuntary holds can vary. For assessments, persons can be held for up to 5 days. For treatment, the person can be held up to 60 days. Courts have very specific forms and procedures that they utilize to carry out the Marchman Act, so you should consult the court in the specific county in which you would like such treatment implemented. I'd like to wrap up this video lecture with some statistics and numbers regarding the commitment process in Florida. Some of this data is a little dated, but it's some of the more recent information that we have about the Baker Act. In 2013, over 170,000 Baker Act exams were initiated and completed. Of those, a little over 48% were initiated by mental health professionals. Almost 50% were initiated by law enforcement, and about 2% were initiated by judges. This distribution has been pretty stable over time if you look back in previous calendar years, with mental health professionals and law enforcement providing the great bulk of Baker Act initiations. The evidence type used for Baker Act initiations has been fairly consistent over time as well. Neglect only accounts for 15 to 20% of initiations. Neglect and harm combined account for about 20% of initiations, and harm only accounts for 65 to 75% of the initiations. These numbers vary slightly year to year, but clearly harm to self and others is the primary evidence used to civilly commit individuals in Florida. In looking at the age breakouts of individuals civilly committed in Florida, the most recent table available is from 2001, but it hasn't changed much over time. As you can see, there's a bimodal distribution for how old individuals are who are Baker Acted. The 2 peaks are from age 14 to 24 and from age 35 to 44. What do you think might be going on at those ages that might cause more people to be Baker Acted? Well, young adults from 14 to 24 are encountering new stresses and oftentimes leaving home for the first time. This is also a time when several kinds of severe mental illness tend to manifest themselves, such as schizophrenia or bipolar disorder. These factors may account for why there's a peak at this age. At age 35 to 44, we can only speculate what might be happening. Perhaps there are a number of life changes occurring at that time in people's personal lives, with their family, with their marriage, etc. Perhaps individuals are having midlife crises at this point. That might prompt a mental health crisis. It's less clear why there's a peak at this age group. What also is interesting from this chart are the number of children who are involuntarily committed. Most likely these are students whose parents could not be contacted by a school, and the school needed to take action to protect the child. At the other end of the age spectrum, you can see that there are a number of older adults who are involuntarily committed. So severe mental illness continues to be an issue on into older age groups. Finally, I'd like to discuss a recommitment chart that was created from 2007 data. As you can see from this chart, over 80% of people Baker Acted had that happen to them only once in calendar year 2007. About 18%, however, had multiple Baker Act initiations during that year. That's something that can happen, where someone is stabilized in the hospital, is released, and then has another episode and has to come back into the hospital for care. As you can see, about 99% had between 1 and 4 Baker Act initiations during that year. What is interesting, though, is the 1% or so who have had many more recommitments during the year. 114 individuals had 10 or more involuntary examinations that year, and one person had 35 examinations in 1 year. It makes one wonder whether the Baker Act system is being used in an inappropriate way, such as to house individuals who can't be housed in any other way. Or maybe the system is too fragmented to provide continuous appropriate care for these individuals. Again, this is interesting data about recommitments and about how the system works for some individuals. This concludes this video lecture on involuntary civil commitment. I hope it has provided a little more insight about this very important system of care for some of our country's most vulnerable citizens.